There's a few things to address, Your Honor.
At the start of the hearing, the judge lays out the stakes. Two defendants, both wanted in multiple states, both begging for bond. He warns them that he must decide within minutes whether they're safe for the community and whether they'll actually return to face justice. The pressure in the room spikes instantly.
Address, Your Honor. There is a bond violation currently right now, and we of course want to address that. I believe it occurred on the 19th of January, her being, I think, either 14 or 17 minutes late against the curfew. And so when I spoke with my client on this, she explained it as far as what the situation was. This was the Friday right before the big snow, and everyone was going crazy. Of course, we all anticipated like it was going to be the last freeze. So she went to the store to be able to get supplies and load up on all of the necessaries, as everyone felt they should. And of course, the stores are crowded. Traffic is everywhere. Prior to going to the store, my client—
At 1:15, the judge hears the first defendant's record: financial exploitation of the elderly, computer fraud, theft, and now a fresh out-of-state hold. Multiple states, multiple victims, and no prior bond made. The judge cuts him off. It's not happening. One look at the file and the answer becomes a hard no.
My client took her 3-year-old daughter to her 70-year-old aunt's house. And the reason being is because, one, her daughter is special needs and she just does not do well in a social setting. And recognizing that it was just craziness, she had to take her there first. Lines along, everything, once she leaves the store, it's apparent that, she very well may not be able to make curfew, but she did have to go get her daughter.
So we only have the one violation at 7:15?
That's correct.
Is that it?
That's it.
Okay. Come up, Mr. Treadwell. Ma'am, it's not the end of the world. I get it. But bond conditions are bond conditions, and you have 2 open DWIs, and you must understand that you and I are operating under strict compliance, and we'll give you a pass now. It's not going to happen again, though. Do you understand? Okay. All right, counsel. We're good to go.
Other matter, Your Honor, we did also want to approach on the court's consideration, or more so reconsideration, of the recommendation for inpatient treatment. Now, we visited this previously.
Correct. And every time I deviate from said thing, we end up regretting it.
And
10 times over. So
you shared that with us last time. I do understand that. I at least want to do my client a little justice and at least give him some reasoning behind.
At 3:10, the spotlight shifts to the second defendant, wanted in California for sexual battery. No local criminal history, no hidden cases, but the charges are severe. The judge warns him plainly, if he gets a bond, it'll be high. And if he runs, he'll face a nationwide warrant with 0 bond next time.
Why we believe outpatient would be a little more appropriate. So the first thing is my client, she has been sober for 103 days. She has exercised diligently and staying committed to sobriety. While she has been released, she has been regularly attending AA meetings, meeting with substance abuse counselor who just had a home visit with her a few days ago. She has obtained her health insurance, which was previously lost due to the loss in employment, but now she can further recovery by taking advantage of the psychiatric care, therapy, and whatnot. And 2, and this is really primary, the family circumstances. The circumstances of the family are the type that requires my client's presence at home. She is the caregiver primary caregiver of 2 daughters, ages 10 and 3. The 3-year-old, as we shared before, is a special needs child. And when she was in custody after the second offense, it was her parents who did take care of the children.
So luckily we have that going.
Well, yeah.
Have someone to watch the kids.
Yeah, and that was for just about 30 days or so. Definitely.
At 4:55, after arguments from both sides, the judge reaches a decision. Bond will be set, but at half of California's original amount. He gives the defendant 2 weeks to self-surrender. One failure, one delay, one missed deadline, and everything resets. The judge reminds him, I don't play games.
Definitely operated as a hardship as the parents. And of course, in these kind of situations, there's going to be sacrifices. Sacrifices has to be made by all parties. But we're talking about now 180 days, 6 times that amount, which, you know, again, I think it would be a tremendous hardship. And particularly with, you know, I think a lot could be said about it, but particularly with the special needs child, what we do know about that demographic is they need routine. You know, routine is keen in their lives. If that is removed, it's, you know, they could get discombobulated and you know, it could operate as a crisis to them. So what we do know is if she does have to go to this outpatient program, home is no longer going to be there. They're going to have to move with whomever.
You say she doesn't have health insurance?
Oh, she does. She does now. She obtained it as of July 31st. July 31st, right? Yes. I'm sorry, January 31st, excuse me. But yeah, so they would have to move. They would have to switch schools, just uprooted from the life that, you know, these girls do know and understand. And again, particularly with the special needs one, possibly not even be able to attend, is it occupational therapy? Speak, and occupational and speech therapy. Thirdly, Your Honor, when early on in this case, I had acknowledged, I had informed the court of my client, she is prescribed Adderall. And at the time of the offense, during the time of these offenses, her therapist had, you know, they were adjusting her meds, even had her on an extremely high dose of Adderall. And, you know, I don't want to portray myself as an expert in this at all, because I just found this information out. And that is that Adderall with alcohol, of course, that's a bad idea already. Okay, but what it does on a molecular level, they're both fighting for enzymes, and the enzymes are what's extracting it, getting it out of the body. The effect is that they mask each other. And so someone that is drinking while on Adderall, they're drinking, they're not feeling the effects. You know, they're drinking and drinking. Your body is not telling you, okay, hey, we're intoxicated. But all the while, of course, the blood alcohol levels are through the roof, even to a fatal level in some instances. The blood alcohol levels here are, they're up there.
How high are we talking?
Hi, Your Honor. You know.
Yes.
Yeah, no, and you know, I understand, and that is
You realize that most people at that level, you know, 0.4 is dead.
That's right.
Right? You're at a 0.4, you're dead. A normal person at 0.3, they'd be passed out 3 times over, right? It's to be able to get to that level at a 0.3 and then a 0.2 on that truly tells me that there is an issue there.
Well, absolutely.
Right? And me, with that kind of levels, right? And we have 2 open DWIs. If I don't follow the recommendation, because that's why we have these people. They're clinicians, they're experts in what they do. They make the evaluation, they make the choices. I understand it will create a hardship, but sometimes that's what needs to happen to gain perspective and to gain knowledge. You know, I understand your plight. I understand your position. Every time I deviate, you regret. She has a 0.3 and a 0.2. What was it? 2.8. A 0.28 and a 0.3 on 2 different DWIs.
That's correct, Your Honor.
I'm sorry.
Well,
Just,
you know, and again, I know that
I understand.
that is
I'm never going to be
attributed
a lawyer for, you know, zealously advocating, and I appreciate it. And, you know, you have to do what you have to do. I understand. Sorry. That's just, it's too much. You know, if it was a 0.4 or 0.14, but we have a 0.3 and then we have a 0.28. Really, it's too much. I don't know how you want to move forward, but I am sorry. I don't want to deviate from it. You know, we can give you time to make arrangements, but I think that that's the appropriate course of action. I'm sorry, Ms. Treadwell, you know, because there are consequences to actions, right? And I know that it's going to be hard, but I think it's going to be all for the better.
Your Honor, I absolutely agree that, when we're talking about treatment, who could speak against that? And I do understand that.
And we're giving it to you for free. You get out there, you're going to have to pay for it on your own. You're going to end up thousands and thousands of dollars to pay for it. I can't pay for a treatment on the outside. I'm telling you, I know that you have insurance. Insurance is only going to cover a portion. When you go to these outpatient treatment programs, they're thousands of dollars.
There is also the KEYS program and the Access program that,
No, she's a 0.31 and a 0.28, really. That needs a lot. That's why they recommended it. And I'm sorry, but, I wish I could make a different decision, but sometimes we have to make tough decisions as well, and I'm sorry, Ms. Treadwell, but I will give you as much time as you need to make arrangements, but I truly think that that's the best and appropriate course of action. Okay.
How much time?
I mean, your first case is your second case is 104 days. The first case is 153 days. So you've got some time, but I mean, we're running up against it. I'll give you another 30-day setting. But that's it.
Your Honor, would we bid in 45 days? Because there's going to have to be some major movement that is done on her end to even try to get someone and make arrangements for the
I will give it to you, but that's it. I mean, really,
I get it.
At the next setting, it's player trial. I'm not going to play this game. I will give you the 45 days, but everything needs to be done by that time. Okay?
Yeah.
All right. Sorry, sir. Please.
Yes.
Mr. Perez, you're charged with driving while intoxicated. You are facing up to 6 months in jail and or a $2,000 fine. So correct me if I'm wrong, that he was out on bond on this case, right?
Judge, I'm not.
Yeah,
Not
we
sure about
gave him
that.
a general bond and he failed to appear. Mr. Perez, we gave you a free bond and you got out there. All you had to do was come back. And when you come back, good things happen. I want you to listen. Your failure to appear, we issued a warrant. We revoked the bond. You ended up going back to jail and you spent enough time to where immigration was able to put a detainer on you. That's why you were stuck in there now. For future reference, when you pick up a criminal case, come to court because good things happen. Had you come back, it probably could have been resolved in a good way for you. Do you understand?
Yes.
You also need to understand that what you're doing now is you are pleading guilty to the offense of driving while intoxicated.
We're actually putting on probable cause.
Oh, you are? Oh, I thought you were pleading to.
No, Judge.
Oh, my fault.
May
Well, it may end up good. I don't know.
Actually, once he was detained, he was taken to immigration almost immediately.
Oh, really?
For the GOP bond, Judge.
Okay. I thought he got out. You sent to immigration?
Yes, he was denied bond and he was
Got
returned.
it.
Judge.
Okay, well, he got a bond, I guess, because of the GOB.
Correct.
So you don't think there's PC?
I don't think there's probable cause in this case, Judge.
Do it up.
Yes, Judge. On December 16th, 2024, at approximately 12 a.m., the officers were stationary on West San Houston Parkway when a prohibited vehicle alert displayed a gray Mustang that was prohibited on the toll road. The officer observed that the vehicle was prohibited since August 25th, 2024, and owed $1,536 to the Harris County Toll Road Authority. The officer initiated a traffic stop. Upon contact with the defendant, who was the driver of the vehicle, the officer observed a strong odor of an alcoholic beverage, red glossy eyes, and slurred speech. The officer observed the vehicle to be registered to the defendant, and the defendant admitted to drinking. Stanfield sobrieties were conducted, HGN 6 out of 6, walk and turn 4 out of 8, one leg stand 3 out of 4. The DIC was read and the defendant considered a breath. The results were .067 and .065. And the officer further